I don't think I have to say much about big tech. I don't think it's uncontroversial that there's an antitrust controversy and several issues about the big tech firms these days. We know that Microsoft still controls a dominant share of the operating system market. Google has 90% of the search market. Facebook still and is growing, has 77 or more % of the social network market. And all of these firms are doing literally hundreds of acquisitions that are all going unchallenged. I think the number for Microsoft's up to 270. For Facebook, it's 90, and it's over 100 for Google of potential nascent competitors. So I don't think there's much to introduce by way of the topic. I did want to just kind of say an interesting story about how this panel kind of got formed. So a year ago, I talked with, at another conference, Tom Ferguson, who's one of our discussants from INET, and sitting next to him is Pia Malaney, who's also from INET. And we talked about a project that we would do called the Antitrust Case Against Facebook. And so I got together with Catherine Ruetschlin, who's on our panel, and another graduate student, Brandy Chase, and we started working on the issue of Facebook and privacy, and as well as Facebook and how we handle situations where prices are zero. At least consumer prices on one side of the market are zero. So about 3 months into the research, I see on the internet a paper, and it's called The Antitrust Case Against Facebook by Dina Srinivasan, right? Srinivasan. And I read it, and it was like, I said to myself, this is better than anything I could possibly do. So I had to switch gears. There really was. There was no way I could equal that. And so we switched gears and we turned to the issue of Facebook's acquisition history and why none of the cases were brought. And we sort of converged on the problem that we have today with the potential competition doctrine. And that's the paper that Catherine and I wrote together, and she's going to present. Now, Judge Waddoups, who's one of our discussants, was originally slated to be at the first session, was going to be one of the discussants in the very first session for the law professors, but he had a trial, and the trial was a big antitrust trial. And it was the Entrada case. So he called me and said, I'm not going to be able to do Friday, and plus, anything I say is going to go up to the 10th Circuit. And so we said, fine, how about coming to the tech session? So he said, that's great. So we switched it. And so as a result, he's here today. Now, the Entrada case was a really interesting antitrust case here in Utah, and the experts in that case are co-sponsors of this conference, Charles River and Associates. And so I'm hoping that Judge Waddoups now the case is settled. Nothing's going to the 10th Circuit, Judge. So you're free. And so hopefully that you can say something about that case. Okay, so that's kind of the story of how this panel came together. And so let me begin with Dina Srinivasan. She's the managing director of Cantor Media, and she has her law degree from Yale and was the editor of the Yale Journal on Regulation. And she received an Olin Fellowship in Law, Economics, and Entrepreneurship at Yale. And again, she's written what I consider a path-breaking article on Facebook's exclusionary practices and privacy policy. Second paper will be Catherine Ruetschlin. She's a professor of economics here at the University of Utah. She's a specialist in labor economics, international trade, and finance. She received her PhD from the New School for Social Research in 2018, but during her graduate years, she was a senior policy analyst at Demos. And she's the author of a recent paper that's up on the INET website about Facebook and potential competition. Then our third presenter is Lowe. He's the Senior Vice President of Public Policy at Yelp, so you know his presentation is going to be about Google. He's responsible for Yelp's policies on competition, open data, and free speech, and he's been active in antitrust matters, mainly involving Google, and he was very persuasive at the EU, and is in part responsible for the big fine that Google paid. So then we have three discussants. Our first is Tom Ferguson. He's the Director of Research Projects at the Institute for New Economic Thinking. Tom received his PhD from Princeton. He's taught at MIT and at the University of Texas at Austin. He's the author of numerous books and articles, and if I were to characterize the work, they involve mainly the rigorous analysis of data to explain political events and social changes. That's my own explanation of reading his work. He's on the editorial boards of the International Journal of Political Economy and a longtime contributor to The Nation. Malaney is a co-founder and director of the Center for Innovation, Growth, and Society, and is a senior economist at the Institute for New Economic Thinking. She received her PhD at Harvard and has held positions at Harvard's Kennedy School of Government. And her work focuses on, if I were to characterize it, she basically has her hand in everything going on in Silicon Valley. If there's research, she knows what it is. If there's things going on, she's somehow involved. So she's a great discussant for this panel. And finally, Judge Clark Waddoups. Judge Clark Waddoups is a federal judge here in Utah. He took the bench in 2008. But before that, he was known as probably the best antitrust lawyer in Salt Lake City. He was, I think when he came to Utah, I think about early 80s, probably 1981. Before that, he was at O'Melveny in California, where he was an antitrust lawyer. And throughout the 80s and the 90s, he was one of the top lawyers here. He was at the firm of Kimball Parr, and eventually became a named partner at the firm of Parr Waddoups. Before taking the bench, he and I worked together on many cases. So he knows what he's talking about. He's one of our best judges. And so we're happy to have Judge Clark Waddoups as well. So with those introductions, I'm going to begin with Dina.
Thanks, Mark, and thanks for having me, everyone. So I've been asked to tell the story that I tell in my paper. I guess I'll do that and try to keep it short. So I was in the industry. I'm actually no longer in the industry. I'm just researching and writing. But I was in the industry for about 10 years, and I remember in June of 2014, Facebook did something in the industry that all advertisers and everybody in the marketing industry just went nuts over. They basically decided, they deprecated consumer privacy to enable them to basically track users online by their real identities. And the reason why this is so significant is because about 85% of all advertising in the US this year will be traded on real-time exchanges that are like stock exchanges. And when a signal goes into those exchanges, part of that signal is the user's identity. So the more precise and accurate that user identity is, the more money that Facebook can make selling advertising. not Facebook, but Google did the same thing. And their ability to basically deprecate consumer privacy explains why 9 to 10 out of every new dollar that enters the digital advertising market goes only to Facebook and Google. So the market is actually shrinking. If you take those two companies out of the market, all growth is going to those two companies. So I thought this was really interesting, and having studied antitrust, I had been itching to want to take some time off to go back and research it. So what I did is I started at the very beginning to kind of examine what competition looked like, how did social networks compete with each other, and what I found was that social networks were all free, but they can be very profitable when they're free and offering certain levels of privacy. But at the very beginning, they actually competed precisely on the variable of privacy. So the market started with MySpace. MySpace was horrible with privacy. Facebook entered the market, promising higher levels of privacy. And they had the specific promise to not track users by their real identities, or not even to track users at all, off of Facebook itself. So what we have to understand is that Facebook doesn't just collect information about users when you're using the platform. They actually collect information about users when you're on over 8 million other sites and apps that you use all day long, which translates to about 98% of all news sites in America. So whenever you're on the New York Times and reading an article, Facebook's actually recording what you're reading and keeping a record of it, and then using it later to sell ads across the web and its own property. And so the paper really just studies the market entry and the evolution of the market and how these firms competed with each other. And we see as competition decreased, in June of 2014, Facebook and Google Facebook felt very threatened by Google's entry into the social network market. Google pulled out in June of 2014, and that was the same month that Facebook basically flipped the switch and said, we're now going to track users by their real identities on over 8 million sites. So I thought this looked very much like an antitrust problem, because after all, price is not the only thing that antitrust and market power is concerned with. It's also concerned with quality. And yeah, that's about it. That's basically what the paper looks at. It's an empirical study, really, of the market from an antitrust lens.
All right. I have one slide. Is it okay if I
Sure.
put it up there?
I'm sorry.
That's okay.
I'll stay quiet.
All right. As Mark said, I'll be discussing our paper on potential competition doctrine as it's applied to Facebook's acquisition of small startups. Facebook entered the social networking market in 2004 at a time when that market was highly competitive. There were dozens of competing social networks entering the market every year back then. It took about 5 years for Facebook to overtake its most popular rival, which was MySpace, and then about 2 more for Facebook to become the most dominant firm in the industry by a wide margin. Today, Facebook maintains a pretty consistent top 5 ranking in the list of most trafficked websites in the entire world. Over the period from 2004 to now, Facebook attempted to acquire more than 100 companies, most of them startups in competing or adjacent markets. These include deals that transferred key expertise and technology to the company, deals that converted standalone websites, applications, and platforms into features that were Facebook exclusive, and then some deals where products were simply shuttered in the days or weeks after the acquisition. Remarkably, US antitrust authorities took very little interest in these acquisitions, despite Facebook's march to dominance over the concurrent period. Today, I plan to argue that the underutilization of regulatory power in these cases is the deliberate outcome of a shift in the standard of analysis applied to these types of acquisitions. Developments in the law regarding the acquisitions of a potential competitor over the 1960s, 70s, and then entrenched in the 1982 and 84 merger guidelines imposed subjective, imprecise, and in many cases unworkable standards for evaluating a potential competition merger, placed an extraordinarily high burden of proof on the government, and thus inoculate potentially anti-competitive mergers from scrutiny. The issue of potential competition is particularly interesting for big tech companies, both because it's an essential source of competitive pressure in these markets, but also because potential competition mergers are exactly the type they've been executing over the last couple of decades. In digital platform markets, which include social networking, e-commerce, search engines, app stores, operating systems, and digital advertising, there's a particular combination of network effects, economies of scale and scope, and these result in a single firm dominating the market. In social networking, for example, users value the network with the most connections, and advertisers value the network with the most users, leading the market to tip toward one large provider like Facebook. These markets have one other more unique quality that reinforces that incumbency advantage once it's established, and this is what's called a data-driven positive feedback loop. That is, investments in user engagement generate more data. This data can be used to expand into adjacent markets, which generates more data, and all that data allows the firm to sell higher dollar valued advertising, generating revenue that they pump back into the process of amassing more data. This data advantage can pose a significant barrier to entry in digital platform markets, and it forces a consumer to choose between the features of the product they like at smaller platforms and the benefits they get from the data richness at the large ones. Once a digital platform market tips toward a dominant provider, potential competitors are the main source of pressure on the dominant firm to innovate, maintain or improve product quality, and to keep prices low. But if one of these nascent competitors is onto something, if they have an innovative product that is wildly popular, they can capture those same network effects, scale quickly, and challenge the incumbent firm. For this, the company has to show rapid user growth, and it has to attract the funding necessary to sustain that growth. Of course, it's just these two cases, these two features, that attract the attention and the buyout offers from the dominant firm. An acquisition such as this would be evaluated under the potential competition doctrine. This applies to two aspects of competition imposed by the startup firms: perceived potential competition, in which the nascent firm's existence on the periphery of the market imposes a competitive restraint on the dominant firm, and then actual potential competition, wherein a successful startup blossoms into a rival in the dominant firm's core market, reinvigorating the competitive process for dominance. If these sound like effects for which evaluation is fairly speculative, I would agree with you. Yes, they're not just speculative, but they're technical, expensive, and often uncertain to measure or predict. And those are exactly the reasons the court gave for establishing a structural approach to analyze mergers in these contexts, both in the 1964 case, U.S. versus Philadelphia National Bank, and in the Eighth Circuit following that decision. That is, for mergers above a certain threshold, the government bears the initial burden of establishing the thresholds met. Then the burden of rebuttal shifts onto the defendant, and if they're successful, the burden shifts back to the government to provide evidence of harm. In the area of potential competition, the court began to roll back this standard almost immediately over a series of cases beginning the following year and culminating in the 1974 case, U.S. versus Marine Bank Corporation. Over this period, cases including 1964's U.S. versus El Paso Natural Gas and U.S. versus Penland Chemical Company and 1967's FTC versus Procter & Gamble, the courts dismissed the impact of actual potential competition, choosing to focus exclusively on perceived potential competition. They walked back the structural presumption outlined in Philadelphia National Bank and instituted new and ambiguous standards imposed on the governments, such as measuring the, quote, eagerness and resourcefulness of companies seeking to enter the market. In 1973, the decision in U.S. versus Marine Bank Corp, Justice Powell took the opportunity to turn those more ambiguous standards into a general methodology requiring the government prove two preconditions. First, that the potential competitor could enter the market absent the merger, and second, that such entry would produce a likelihood of deconcentration or other significant pro-competitive effects. These standards are exacting, requiring unequivocal proof in the first case and proof of significant yet undefined pro-competitive effects in the second. The Reagan administration's development of the 1982 and 84 merger guidelines incorporated these standards, setting up the extraordinary requirements of proof in the potential competition cases today. The 1984 guidelines impose 4 considerations for a potential competition challenge. Market concentration above 1,800 HHI, with a challenge more likely in cases where the target firm's market is at least 20% of the market share. Entry in the market must be difficult generally, and the potential competitor must have specific entry advantages. And finally, it required an analysis of the deconcentrating effects of the potential entry, as well as the efficiencies in the proposed merger. As I'll show, this development imposes a burden of proof that would deter even the most committed antitrust enforcer. Which brings us to the potential for false negatives in the tech industry, where the problems faced by agencies forced to meet these standards are arguably how we end up with a company like Facebook owning the 2 largest social networking platforms, Facebook and Instagram, and the 2 largest messaging applications, Facebook Messenger and WhatsApp. These examples aren't going to prove that the cases were enforceable at the time of the acquisitions, but rather they'll demonstrate how the development and potential competition just described prevents serious inquiry into big tech acquisitions. So Facebook announced its $1 billion acquisition of Instagram on April 9th, 2012. By this point, Facebook already dominated social networking, and the Google-Facebook duopoly in advertising held the top 2 largest shares of the market, although their shares were much lower in 2012 than they are today. But Facebook was feeling pressure from 2 sources at the time. First, they were scheduled to IPO the next month in May of 2012, so people were closely scrutinizing their revenues. And secondly, improvements in smartphone technology was driving an increasing popularity of mobile access to internet connections. Facebook had been notoriously slow to reorient its platform from a desktop-based platform to a mobile one, and it had not yet figured out how to monetize the mobile traffic that was making up an increasingly large share of its user base. Instagram, though, was one of the fastest growing mobile native apps at the time. And as Facebook had pointed out in its annual report the previous year, it was not only diverting user attention from Facebook, but it was particularly drawing away key demographics that Facebook thought were essential to its future performance and competitive dominance. Photo sharing had been a key facet of Facebook's user engagement since early on, and Instagram's growth to 30 million users in 30 months, its ability to attract the funding necessary to scale, and its founders' stated ambitions to become the next social network were a nascent but formidable competitive threat. The FTC investigated, but ultimately took no action, and it didn't disclose the basis for its decision. But considering the proof required for a challenge under the potential competition doctrine gives a clear picture of the likely prohibitive obstacles involved. First, in terms of market concentration, Facebook's 2 primary markets are social networking and digital advertising. While digital advertising today has an HHI over 1,800, this wasn't the case in 2012. The social media market, however, was fairly concentrated. Survey data from 2011 shows that 92% of social networking users accessed Facebook regularly, with its main competitors far, far behind. But the competitive dimensions of social networking are challenging to evaluate without a standard of measure. HHI is not well defined for markets like those of consumer-facing digital platforms, including Facebook, where the user price is 0. Alternative metrics have been recommended, but not yet adopted, and problematically, the only source of data for those metrics are the merging companies themselves. Thus, measurement of concentration in these markets won't meet the criteria for the challenge. Of all the obstacles involved in a potential competition doctrine, this is easily the most surmountable, but it's just unresolved. Secondly, the Department of Justice will not challenge a potential competition merger if entry into the market is easy. The market conditions discussed before include the network effect, economies of scale and scope, and the data-driven positive feedback loop. These are a unique set of barriers to entry in the digital platform markets. But at the same time, these firms depend on user engagement. which means that even a product with no direct substitutes like Facebook faces competition from any firm that can draw user attention away from the network. Smaller firms offering a subset of features or adjacent products could all be considered potential competitors. Extending that type of consideration would completely undermine the ability of any challenge to isolate the impact from the elimination of any rival. This makes the third criteria in the merger guidelines harder too, entry advantage. The Department of Justice has to show that Instagram had an entry advantage not possessed by 3 or more firms. If it's intractable to identify the limits to potential entrants, it's also intractable to identify the limits to other firms as well. Looking at photo sharing at the time, Facebook was the largest photo sharing service in the world, but there were many desktop and mobile applications that would store or organize or edit or share your photos at the time. Few had the combination of features that would make them a competitor to Facebook, but Facebook could likely argue that any of them could replace the competition lost through the Instagram acquisition. Instagram's entry advantage was specifically their ability to harness the network effects in social networking through rapid user growth and venture capital investment, and that's exactly why they were purchased. Finally, the government would have to show that Instagram's entry into social networking or digital advertising would have a significant pro-competitive effect. This can be done under the merger guidelines by showing that Instagram had a market share of 5% or more. This reverts us back to the problem of market shares in a zero-price market. In digital advertising, Instagram had not yet entered that market, so it could not have an established market share there. It's not uncommon for Silicon Valley startups to delay entering the monetization period of their existence until after network effects have reached some critical threshold so that they can hold on to users once advertising's in place. All this is to say, Instagram's pro-competitive effects lay largely in an uncertain future. Facebook certainly recognized them, having identified Instagram as a threat to its user engagement in its annual report and offering its highest bid for a budding rival to date. Yet a potential competition challenge by the Department of Justice would have certainly failed under its own guidelines. A similar story may be told regarding Facebook's acquisition of WhatsApp. In 2014, Facebook spent a massive $19 billion on the 5-year-old company. Again, Facebook was in a position of reorienting its platform as consumers increasingly sought private platforms for mobile, real-time, one-to-one, or group messaging. At the time, mobile messaging was the fastest growing app category. Facebook's Messenger, the result of a previous acquisition in which Facebook purchased startup Beluga and basically just turned it in to Facebook Messenger, was the most used service in the US, but Facebook Messenger was struggling to gain ground in Europe and emerging markets. That's where WhatsApp was wildly popular, and these are really important markets. At the time of the acquisition, WhatsApp's 450 million users dwarfed Facebook Messenger's 200 million. Moreover, WhatsApp was the largest and fastest growing messaging app in the world. It was gaining users at a record rate of 1 million per day, and these users were unusually engaged, most of them using the app daily with a volume of messaging that rivaled traditional SMS texting. Facebook's acquisition gave them ownership of the 2 largest messaging services in the world. Now, was WhatsApp a potential competitor in messaging? Well, if Mark Zuckerberg is correct in his own assertion that the future of social networking is private, then a scaled-down social network based only on one's existing contacts with a strong commitment to privacy and reliable mobile services, exactly like WhatsApp, would be just the disruptor to reinvigorate competition in the social networking market. But this framing brings with it all the same complications and difficulties posed in the Instagram merger. There's no agreed-upon standard to measure market shares, the expansion of the competitive field for social networking to include all standalone messaging apps, Line, Viber, WeChat, Skype, and then one in which the entry advantage occurs in the form of the capacity to harness network effects. And finally, the fact that the harm to future competition lays in the future. After review, the FTC cleared the merger without a challenge. In the Instagram and WhatsApp acquisitions, the high initial burden to present a case concerning future conduct and competitive effects served as a serious deterrent to antitrust challenges. Under the pre-Chicago school structural presumption, the FTC could have elected to challenge the merger and shifted the burden to Facebook to demonstrate why no harm to future competition could occur and why, given Facebook's resources, it could not internally innovate to achieve its competitive goals. Instead, the government's hands are tied by a potential competition doctrine that involves difficult tests of conduct and performance. In light of big tech's appetite for acquisitions of small startups, including individual acquisitions and patterns of acquisitions that should have raised red flags, we argue that the burden of proof should be shifted back to the defendant, and the wrong turn taken in U.S. versus Marine Bank Corp. Should be corrected with a return to the structural presumption that was in place before the Chicago School Revolution. Thanks, guys.
Good morning. Good morning. Before I get into intro, I want to do a simulation, a live simulation with this audience. So I want you to imagine that the year is 2013. The Federal Trade Commission has just completed a very mild slap on the wrist to Google for alleged antitrust violations, and you are the head of the European Commission Competition Bureau, and you've decided, well, we're Europeans, we're going to be a little bit tougher than the FTC. And Google has said, hey, that sounds good. Tell you what, we're going to give you a better deal than what we gave the FTC. Here are some mock-ups of what we're willing to do to make this whole problem go away. And you're presented with two options. This is option A up on the screen, and it is presumably designed when one does a search, for example, for cafes in Paris to drive traffic to rivals in this sort of rival links module. So you can see we've got Page One, which is the French Yellow Pages, via Michelin, and Yelp. That's one treatment. This is the alternative treatment. Some diminutive links up in the top right-hand corner of what's known as the one box. So I'm going to show them again, and I'm going to ask everybody. So we'll call this A and B. Everybody got it? A, there's B, there's A. And your goal as an enforcer is to maximize the amount of traffic that goes to third-party rivals. So how many are going to pick A? How many are going to pick B? Okay. The behavioral economist in the audience doesn't get to vote because she already knows this story. Okay, so I'm going to talk a little bit today about the sort of information asymmetries that exist when enforcers are hoping to make difficult decisions, high-stakes decisions like that. And I'm not a lawyer, I'm not an economist. I've been at Yelp, though, for 12 years, and I've worked on the antitrust issue for about 8. My kind of educational background was I studied political science and math, and was interested in college in kind of political polling. If I have any kind of claim to sort of academic relevance to any of this. But I think the best experience has really been sitting alongside and sometimes actively designing products. And I think very often what I observe in sort of the enforcement arena is this wide disconnect between sort of what Brussels and Washington, how they're thinking about these problems, and how the products are actually designed, and how product managers think about this stuff. So I'm going to talk a little bit about and tell a story about how Yelp overcame some of these information asymmetries, helped enforcers address these information asymmetries. Because the real problem when you are an FTC or a DOJ or a state AG or the European Commission or any of these authorities hoping to look under the hood and understand if this firm's acting in an anti-competitive manner is that the firm is typically holding all the cards. And the ability to negotiate with somebody like that is pretty intimidating. Sure, you can send CIDs and subpoenas and just get a petabyte of document dumps and hope to swim through that and suss out some type of harm or foreclosure. But what in the story I'm telling, I'm going to talk about how there are actually elegant, inexpensive, rapid, simple ways to kind of work around that and empower enforcers with better ammo. So the TLDR of the Google case, if we go back to, it goes really back to 2011 when the Federal Trade Commission opened an investigation and for 18 months looked into the question of whether Google was abusing its dominance. And I'm going to kind of like skim over, I know that there were other aspects of the case, people talk about Android and AdSense, and I'm just going to be talking about sort of search bias, and as it relates to local search. Of course, the Europe case ultimately, charges were brought in comparison shopping, but I'm just going to talk about a little bit of the TikTok as it related to search bias and local search. But basically, the FTC, to paraphrase Google's defense, they said, hey, listen, one day we had 10 blue links, and then we thought, gosh, we see some people typing in 2 + 2. Why don't we show 4s on the screen? That's going to be so much easier for people to get the result they're looking for. They don't have to click on calculator.com, re-enter the 2 + 2. It's lowering user search costs. Sure, the guy that runs calculator.com is getting screwed competitively here, but in the United States, we do a balancing act here, and we've determined that on balance, consumers are benefiting from the introduction of answer boxes on the page. And so when people do searches for what's the Washington National score, or what's 2 + 2, or what's the weather today, we're just going to put a box that answers the question right there on the screen. And the FTC said, gosh, that sounds pretty reasonable. And where I think, and personally believe that the FTC failed in their analysis is not looking at sort of vertical specific questions, because I think whereas 2 + 2 = 4 is on one side of the spectrum in terms of the nature of the information that the user is looking for, pediatrician Salt Lake City's over here. And but nevertheless, the FTC took a look at this. We felt, we were very naive at the time. We're still pretty small, kind of startup sized, had no outside attorneys or economists, and we just earnestly responded to the RFIs from the FTC, and it seemed like the staff understood it. We learned later through an inadvertent leak of the staff memo to, half of the staff memo to the Wall Street Journal that the staff sort of got it. And so we thought, we were actually generally optimistic that the FTC was going to bring charges. And so we were really bummed when, on January 3rd, FTC came out and gave Google a clean bill of health, said some of the past stuff they've been doing, we've done a gentleman's handshake, they're never going to do that again, and Google can proceed as planned. And this teed things up, and that was John Leibowitz, who's in the top left-hand corner there, the chairman there, who said basically, this looks good to me. And then things were passed to Brussels, who had technically opened their file in 2010, but it was a matter of public record that Leibowitz and Almunia had been communicating a lot about the case, and that the European Commission was poised to do something a little bit like what the FTC had done, but just a bit tougher because they're the EU, right? And so Almunia announced what's called a market test and looked at a bunch of different options and ultimately didn't go with what Google was proposing. This led to the entrance of Margrethe Vestager, who actually just got an unprecedented second term. You've probably heard about Margrethe Vestager. She was the one that in April 2015 actually announced she was going to do a statement of objections against Google, formal charges. And really, I would argue, kind of kicked off the techlash as we talk about it these days. So these were the different proposals that were put forward. You all actually just voted on one. I think the treatment we were comparing treatment 1 and 2. It looked like treatment 2 had a pretty healthy majority in the room. And then actually there was a third treatment that was sort of a variation of treatment 2, where they took the rival link concept and put it up at the top. And so today I'm going to talk about why Europe rejected those settlements, how Yelp was involved, and what broader issues, broader lessons exist for enforcers going forward in the Google case and really beyond the Google case. So when Europe announced this process, they call it a market test. And what was interesting is that market test doesn't really have a formal definition. Like, we could have gone and done sort of an interpretive dance of why we think Eric Schmidt is a bad guy, and that would have technically counted as our market test. There's really not there's not rigid instructions about what market test actually means. And so we took that as meaning, gosh, we have to develop some type of empirical process to tell Europe what we think about these screen mock-ups. But the problem was, in order to really understand whether or not these mock-ups were good or bad, we had to be able to look under Google's hood. We had to understand would the actual performance of these screens be if we release these screens into the wild. And so this was the information asymmetry I'm talking about. And so how do you do that? And so we brainstormed a lot and ultimately figured out that that when you are designing a product, an internet product, very often if you're an app developer, there are these platforms for usability studies where basically you can say, okay, I'm thinking about I'm debating whether to put a red button or a blue button on the screen here, and you ask 20 people, 15 people say red, and so you go with the red button and continue with your day. And that's how these products typically get made. And it's usually with a small amount of people you can kind of get an understanding of a pretty simple binary question like that. But what we were trying to get at was, like, we need lots and lots of people to understand, because there's lots of different things to click on a search results page. But this process of sort of bringing data scientists to the party and giving them sort of a longer leash than the lawyers ended up being useful, because what ended up happening was we were able to develop this methodology to predict how people behave given a hypothetical search results page. And one of the real ahas that we had was using Amazon Mechanical Turk. Has anybody here not heard of Amazon Mechanical Turk? I assume probably most people, right? Wow, most people have heard of Amazon Mechanical Turk. Has anybody, raise your hand if you've never heard of it. Yeah, most people, right? Okay, so Amazon Mechanical Turk is a marketplace where you can go and, if somebody were like scribbling notes of this talk right now, and they took a picture of it, they could upload it to Amazon Mechanical Turk and say, I'll pay somebody $5 to type this out. Or it's basically a site where you can enlist people to do micro jobs. And so we figured out a way to hook, and there are literally tens of thousands of people just sitting around waiting to get paid, 5, 10 cents or $1, depending on the complexity of the task, as long as it can kind of be sort of consummated and facilitated online. And so we figured out a way to sort of hook this usability hub to the Mechanical Turk fire hose, and we're really blown away by the results. So actually what I wanted to, in my demo, show you how do a live example of Mechanical Turk. So today we've got actually really good attendance. I was really expecting lots of people to drop off, given it's Saturday morning. So thank you for coming. But I'm going to invite 200 more people to the party this morning, and we're just going to ask them to do the same test that we just did. It's going to cost me $28. I don't mind biting the bullet on that. Okay, so now that's in the hopper there. So we'll revisit that in a minute. So basically, Mechanical Turk allowed us to understand how people are behaving given these hypothetical search results page. And what we found is that when you're doing a side-by-side test, when you're comparing sort of treatment 1 versus treatment 2 and looking at them next to each other, treatment 2 obviously looks a little bit better, because you're literally increasing the pixel area of these rivals. You're putting logos on the page. Here, I'll go back to it. You're putting little blurbs about what the website does. But it turned out that relative to treatment 1, that the click-through rate actually dropped. In other words, you need to give users, you need to put them in the driver's seat. So we had this insight that a search engine result page is not unlike a ballot screen. And just like there's a whole industry dedicated to calling people a couple days before an election and saying, hey, the election's in a couple days, who are you going to vote for, and getting accurate predictive data, you can do the same thing with Google screens and actually virtually any consumer-facing internet company. You put the user in the driver's seat, you say, hey, imagine you're in Paris with friends and they've asked you to plan dinner. Or you're in Paris with friends, and you're getting hungry for lunch. So you decide to type cafes in Paris, and you come up on the polling page. What are you going to click upon? And what that produces when you put that type of question to Amazon Mechanical Turk and send lots of users to these platforms is lots and lots of really incredible visual data that helps us understand where the hot spots on the screen are, where people's engage with, and it gives us a peek under Google's hood, and it really only is very inexpensive and takes 20 minutes to get statistically significant results. I was blown away by this because it was so inexpensive. I mean, the tests on average cost about $20, and they're so fast, again, takes about 20 minutes to get data, that I thought this can't be accurate. This has got to be garbage data. And so we decided we had an insight that, well, actually Yelp is a search engine, so we can take screenshots of our search results page, put people in the same type of driver's seat, and cross-validate it, because we can look under our own hood. And it turned out that this cross-validation method worked. And so we feel confident with the accuracy of this. And so this is really powerful, because it enables us to understand how people are behaving without having to subpoena Google data, and it suddenly introduces the ability for, and the thing about it is that it's not, there's no reason Yelp is special. Any Joe on the street can do this. And so what we were able to find is that when you put people into sort of a randomized controlled setting, and you give a variation of, say, status quo Google to see what percentage of the clicks are going into sort of the Google box versus the 10 blue links versus the rival links, that would be an experimental treatment, versus a treatment where you just remove that thing and have a control group, and you measure sort of what buckets people are going into. What we found was that going from the first treatment, which had sort of the diminutive text in the top right corner, to the second treatment, where you're blowing up the rivals and increasing the logo, putting logos on there, giving them little blurbs, there was actually a drop between the click-through rates in the first treatment and the second treatment. Now, what was going on in Brussels at the time was everybody thought that Almunia, the commissioner, was rejecting the first treatment just as a negotiation tactic. And so by the time the second treatment came along with big logos and blurbs for everybody, he said, this looks good. He was going around Brussels saying, we're going to accept this thing. And so when Yelp was showing him data that actually showed, when you put users in the driver's seat, the click-through rate from treatment 1 to treatment 2 drops by an order of magnitude, they were shocked. And I think it was even shocking to us. I think it was really revealing that it just underscores the point that these firms are holding all the cards, such that they can literally increase the pixel area of a rival link and decrease the click-through rate. And we know that they, of course, are running these experiments before they hand any treatment to the enforcer. And so this aha moment for us was really profound, and has led me to sort of quietly evangelize this process to as many enforcers as I can, and this is the first time I've publicly talked about it, but I think it's a really profound and important point, and it has a lot of critical applications. Let me just peek at the time here. Okay, so I'll show one more. Let's just jump to the live data here. So we've already got, for example, I've invited 200 people to the party. We've already had 50 take our our side-by-side test. And we can actually see that the majority of people agreed with this audience, that in this case we gave them a side-by-side test. Well, what do you think of, imagine you're trying to drive traffic to a third-party rival, and we see that the majority of people who are taking this live test right now believe that the bigger treatment is going to lead to more traffic to the rival. And yet, when we go into the actual performance of the rival links, we can see that relative to treatment one, this rival link is basically a dead zone for clicks. It's sort of where clicks go to die. And so, again, it's a very exciting process that I think gives enforcers just this incredible weapon in overcoming this information asymmetry. There's some important applications that are literally we're using now as the DOJ and the state AGs look into this. One of the applications is understanding sort of the foreclosure effect when we have a growing web. So more people are buying phones, more people are conducting searches, and so if you're a big tech firm accused of foreclosing rivals, your defense is going to be, well, in TripAdvisor's last quarterly earnings statement, they were talking about how they were growing up and to the right. But you can't simply look at the absolute traffic of a particular rival or complainant. You have to look at how big is the absolute pie, how big is the supply that Google could potentially provide, and what is the slope of growth of the siphoning of traffic that Google is giving to itself versus the growth of all these third-party rivals. And so tools like this enable us to understand what that rate of siphonage is. It also helps us with, you can imagine, remedy design. Tim Wu was speaking here yesterday, a couple years after we sent all this data to the European Commission. Tim Wu, a Harvard Business School economist, Michael Luca, and I worked on a paper showing that if you did a treatment of this box, which had the box powered by third-party rivals from across the web instead of status quo Google, that the click-through rate of the box would actually jump by 40%. And so, imagine, for those of you that are familiar with the kind of browser choice screen from over a decade ago in the European Union, where Neelie Kroes, the European Commissioner then, was basically negotiating with Microsoft over how they're going to restore competition in the browser markets. They looked at the designs and they just released it into the wild and hope for the best. This is effectively what I'm talking about here, is a crystal ball that enables people to understand what's going to happen in the market before you release it into the wild. And I think there are applications beyond search. Dina and I, a few months ago, and sat down in Chicago, I was really, I loved an example that she had created about Facebook, looking at what would, what if Facebook had sort of an opt-in mechanism on privacy. Let's see if I can actually zoom in here. Yeah, so, can't really read that. Do you want to explain that?
Yeah, sure. So, one of the things I think in these zero-priced markets where the products are free is you start to scratch your head and wonder, well, what if you get into this debate of, well, Facebook is going to say it's better quality, like the more tracking we do, the better ads that we can give you, and this is really just a consumer preferences question. And I think even with price increases, we presume that a price increase is always the measure of damages, but again, it's a consumer preferences question because quality is never constant, and maybe some consumers really like the fact that you change the color of the pill and like you're paying 2 cents more or whatnot. So if we just think about it as a consumer preferences question, then this tool becomes incredibly valuable because, one can argue that Facebook's depreciation of privacy in 2014 was bad for consumers. They're going to say it was great for consumers. We can run a test, and we can show what consumers actually prefer. And we can run it with 100,000. We can do 100,000 in the U.S. And if users are driven to select their choice, what were the results, Luther? I think-
Basically, nobody wants to opt in.
Yeah, I
to
mean, I
being
think it's like
tracked.
99%, right, don't want that, don't want that. So,
Yeah.
yeah, so just, I mean, I just think about it as, a type of proof that can be used in courtrooms in these types of cases.
So even though it's, most of my examples are about Google, I think you could really, there needs to be more research into this, and I think more people need to be taking this up than just a team of nerds at Yelp. And I really would love it if some enforcers started taking advantage of these tools. This is how you get started. Just get on MTurk and Usability Hub. There are a lot of great videos online. I'm also happy to speak to anybody, but I think the basic idea is here that Silicon Valley firms build and entrench their dominance with the lessons of Kahneman and Thaler, i.e. sort of experiment-based behavioral economics. And when they get big enough to invite antitrust scrutiny from DC and Brussels, they point to these sort of Bork neoclassical arguments, these defenses like competition's only a click away. And there's no reason that enforcers shouldn't be taking advantage of this Moore's Law for enforcers, rapid and inexpensive and accurate experiments that enable them to look under these tech giants' hood and actually understand user behavior. That's all I got.
Tom?
What's that?
You'll have to reconnect the.
So we peaked at it at 25%. It was but the majority had indicated that of treatment too. So Google tricked the audience and the Mechanical Turk audience.
Hi, folks. I figured I'd better stand too, less because of any merits of the PowerPoint. I am PowerPoint challenged, and I admit it. I did it last night. But because I was afraid of putting you all to sleep. And, in my house, the household god is Morpheus. But I don't want to do that this morning. And so all I want to do to get started is to thank Mark, Catherine, the others, and their colleagues for throwing this conference. And their colleagues at the University of Utah, and I have to say I'm actually having a fairly good time, which is very unusual for me in conferences. I'm also, and this particular panel, I'm sort of in the difficult position because I actually agree with virtually everything. This has almost never happened in my life. I just want to do a couple of things here and get out fairly quickly. One is, I want to make a few general remarks about the Neo-Brandeisian school. As you can see, that there's unfortunately a mistake in that line. I didn't fix it last night. And then I want to talk specifically about the papers very briefly. I'm not planning to go on a lot. What I do want to begin by saying, look, we all owe the Neo-Brandeis school a lot, okay? I grew up in graduate school. I was working with William Baumol, who invented a doctrine that I think is quite pernicious, that potential competition doctrine, which I don't think could be too caricatured as saying there's a competitor under every rock. That's just not true. I remember a friend of mine, Herman Schwartz, who was in the Antitrust Division of the Justice Department, who was debating Baumol, who was the main guy for AT&T. And they went on and on. There was actually someone insanely in, I think, Mississippi. And at the end of it, Herman walked over to Will and said, well, Will, do you actually believe there are economies of scale in the AT&T thing? And Baumol then just looked at him and said, I didn't say there were. I said if there were economies of scale. Later, a colleague of mine and sometime co-author, Peter Temin, was hired to write a paper for AT&T. They ditched the paper. He said there were no economies of scale, and that was the end of that. Alas, that paper did really disappear. Anyway, I think when you read the Neil Brandeis materials, and we're going to accept that it's a cloud. I mean, it's not quite clear who's a Neil Brandeis. Somebody will say, I'm Neil, but not Brandeis or something. Okay. Look, these are very romantic images. When I read their stuff, I think back when I was sort of reading as a young student. It reminds me very much, and I think, in fact, that's when you look at the citations, they're often to the old-style progressive historians with a small p. And by this, I don't mean Charles Beard or somebody. I mean Schlesinger, Leuchtenberg, and things like that. Now, there is a ton of material that has come out since. I've dug up a lot of stuff, too. But I think Kulko and Martin Sklar's work, I mean, these folks need to be critically reassessed in any modern treatment of antitrust. And moreover, you're beginning to see, I mean, I'm never a big fan of most of what mainstream economics does, but there is this tool called event analysis. You can use it to analyze things that you thought you couldn't ever get at. For instance, you can't find out, well, all right, my favorite paper on this was one a colleague did early on, where he looked at unexpected deaths of congressmen. It has to be, and women, although I think all his cases were men. And it had to be unexpected, otherwise it'd already be in the share price, roughly. That's not a commitment to any crazy theory of perfect markets. It's just a fairly commonsensical line there. And what he found was when congressmen died unexpectedly, the stocks of companies they were close to dived that afternoon. That finding hasn't really been taken too widely outside of economics. Lots of people, myself included, have used it on cases. But there is now a really excellent paper on what happened when McKinley was shot. And looks at the folks, I'll talk about it for 1 second in a few minutes, but what you discover is that, yeah, the companies with the biggest proximate sort of potential antitrust problems, their stocks took a big dive. Most of big business did not. It's a point that supports Kulko's all-important point that Roosevelt was quite a relative conservative. I mean, this guy was not generally out to busting trusts. He had a clear distinction between good and bad trusts, and he made it and he used it. And this stuff, too, is not taken. I would add that as much as I think very highly of the work, say, on labor monopsony, labor market monopsony, or the correlative claims about income distribution, you need to look carefully at those. I think you'll find that those are overstated in terms of the economy as a whole. Like some of our work at INET, Lance Taylor's papers, in particular, where he sort of goes way beyond Piketty, does not just the distributional, but the product side of the account, so you can look at where value added is coming from in industries there. And you can just, a quick look at that will show you, look, it can't be the case that monopoly is basically what's wrong with the U.S. income distribution. This is not to say there are not plenty of monopolists. You've been hearing about them all morning, and everything everybody said is true, which is my main message about those papers there. And beyond that, it just can't, it's wage repression and basically macro policy and bluntly the Keynes principle of effective demand, along with a kind of bogus analysis of potential output, which is the Palumbo paper, a really brilliant piece of work, I think, that we put out not too long ago. These folks, that's where your real depression of wages over long periods is coming from. You know, New York and places like that, you've got hundreds of restaurants. It just can't be the case that we're dealing with monopsony. This is not to say that there aren't important cases, and in particular in the design of platforms as in the future for the gig economy. This stuff is, the stuff I've seen, if I haven't looked at this myself, but it is said that if you're trying to use these, you can't even sort it by price to figure out what you want to do. If you're trying to sell yourself on the gig economy, like that stuff should just be banned. And but that's not my major sort of point. Anyway, my suggestion is people got to stop overselling this because you're going to miss the really important, some really important things one would hope another administration would do. and you're going to, I think, work to enforcement problems on the things you are trying to do. Now, just a few remarks on the history. You can read slides, so I'm not going to try to do that. And I know everybody's overwhelming tendency is to just look at the slides and not anything I'm saying. I get it. I do the same thing when I'm listening to people too. But look, I taught at the University of Texas for some time. So I knew lots of oil people. And some of them were still alive from the New Deal. And the blunt truth is that antitrust as a case in America, until very recently, was largely being carried by the oil industries, the smaller firms in there. And they had an enormous impact. The reason they had this was because you could get very wealthy, fairly occasionally in the oil business. Like if you pull a list of the biggest taxpayers in the 30s, I've done it, so I know what I'm talking about. Of the top 10 folks, 2 of them were small, relative, independent oil people, Sid Richardson and Clint Murchison. And these folks were all generally, even when they moved far to the right later in their life, they were all enthusiastic antitrusters. And they had real interest, real influence with Roosevelt. I've worked a lot on that period, but I'm not going to just push it. But the disappearance of the oil industry as a sort of significant factor that maybe we're going to see that picked up by the tech industry, which shows some of those patterns. That is to say, you got some giants that dominate it, but then you got a large number of fortunes and firms out there that make considerable amounts of money and are relatively affluent by the standards of what it takes to get into politics. I think that is perhaps partly happening right now. Anyway, when you look at Roosevelt and the antitrust stuff, which actually I'm surprised how few people have. Thurman Arnold's papers are over in Wyoming and Laramie, and I think it would be very useful if somebody at this university just, took a motor trip over there and looked at them. I did. That's what. But you will find that the so-called Taylor Society, I wrote about that in several papers, was Henry Dennison and Lincoln Filene and actually Ralph Flanders and people like that. They had a kind of outrigger status to some parts of the business council, and the Taylor Society people were pushing antitrust, and in the mid-30s they had some real influence. The difficulty is that the New Deal almost immediately fell apart, meaning that Roosevelt did exactly what other Democratic presidents were doing, although he had the good sense to do it early in his second term, not his first, and kill economic stimuluses. They famously, Mariner Eccles from Utah raised rates, and I can tell you, because I was in those papers, that he was having construction wages. He owned one of the big 6 construction firms, Utah International. Some of you will still perhaps remember that. It was sold to what, Morrison Knudsen, which then turned into something else. Anyway, he was looking at construction wages, and he was having them brought to him every week by his people. And so they raised rates on that. They thought, they actually thought wages were too high in 1937, which is very hard to sustain when you go back and look, although I noticed that some economists have tried to make that case even again. Anyway, the point here is that the antitrust stuff in the New Deal is a very mixed bag, and in the literature on the Neo-Brandeisians, they pass by nearly all the complexities, and lots of the stuff on the comparisons with Germany, which people are making, they were making them yesterday. This is very facile stuff. I've written a lot on the German economy, and I ran the event analysis that people should have done to see who actually put Hitler in power, and yeah, I found that what I'll call the conventional Nuremberg account was correct. But trying to jump from large firms to political autocracy, one has to be extraordinarily careful, and most of that early research, even though they were, at the time, they were way ahead of everybody else. I mean, the old Brady pieces, or more recently Bettelheim and these folks, but they just miss a lot. There's just an enormous amount of archival stuff and writing. Most of that is unfortunately in German, but if you're going to talk like this and you're going to make national policy, at least try to like that, you've got to be, I think, a lot more careful. Now, I've already talked about that, But this point I want to make, the big thing in the Hiltz et al. Paper on McKinley's assassination is the overwhelming importance of enforcement. Because basically, the whole of the antitrust policy of the United States changed a lot when Theodore Roosevelt took over. No doubt about that at all. And the law didn't change in any serious way for a good while, which leads to this problem that always preoccupies me, the question of money in politics. And I cannot believe that our Neil Brandeisians are so blithely slipped by this problem. I'm going to just compress this into 30 seconds. My colleagues and I spend a great deal of time taking apart and putting back together all the federal data from the IRS, which handles a lot of so-called 527 money that's normally left out, and then the FEC cash. We stick it all together. We do all kinds of things with it to try to find out how many of these people are really the same people, which is basically what nobody else does. That's why our rates of concentration of contributions, we always get much higher rates than everybody else. That's because we've taken the trouble to sort through, like the people who just give their initials, who have multiple addresses and things like that, and then we will match them with business directors. Anyway, what we discovered early on, this graph is actually for 2016, is there's a virtually linear relation between total spending and party votes. Now, everybody's reaction was, this is impossible, this is some kind of thing, or the money must be following the polls. Well, okay. Now, in fact, it turns out that every election for which we have this data from 1980 forward shows this pattern. And then you can, my colleagues and I spent several years working up some fairly elaborate tests. We use the Iowa markets data as instances of conventional expectations. We can show you that the money doesn't follow polls. But it really matters. And I would like to observe this, having spent a lot of time in political money stories. The so-called 527 funds, I have often do by hand, trying to figure out, I will have a list of, I've actually done this, 5,000 little plaques or something, and try to figure out, are these Republicans, are these Democrats, who's this, what's this really about? And I found just about 7 months ago, I found a whole block of PACs that were essentially, they turned out to be just channeling cash, this is in the federal side, to Michigan legislators and other state legislators. This stuff is going way down into the system, and really nobody's paying attention. And the other side of this is companies pay a lot of attention to state attorneys general. They have a whole Democratic and Republican states attorney general funds. You can read that one you can pull up. You might even be able to Google it, though I haven't actually tried that, and Mr. Lowe's thing reminds me of just how suspicious I need to be about search. But my point is, when you start looking at state attorneys general, they're on board now with these suits, thanks to, I know, the efforts of some people on this panel, in part. Whether they stick with this, let's see. I spent some time trying to convince the Massachusetts Attorney General that they ought to sue because of the LIBOR, the interest rate fixing that was very nicely demonstrated, and it turned out the Boston MBTA had a ton of bonds, and they've been paying on these things forever. And private people were suing, almost no state did. It's remarkable. Now, I mean, I never make a statement about any individual's mental state, but it's a fact that that Attorney General in that office, she was trying to run for, what was it, governor or something, I forget. She wanted the higher office. Anyway, she didn't get it. The other thing I urge people to pay attention to is, when these tech execs testify in Congress, are they sworn or not? I've been in some cases, I'm pretty sure from 1 or 2 press accounts, they aren't always sworn. And I noticed that Elizabeth Warren's statement the other day said, when they were talking about Facebook, it should be under oath. you've got to really watch the way congressmen and women deal with Facebook. My own judgment is that many of the people most prominent in the national debate now in Congress, not Warren, who Warren is for sure, I think, real on this, they are, I think, actually fairly friendly to Facebook. I think it's fairly easy to demonstrate. My colleagues and I will undoubtedly tackle this later. But you got to watch really closely. There. Finally, yes, this is just all of the linear model data for all the House elections. It's always the same pattern. This, however, is what I suggest everybody cogitate about right now. This is size contributions coming for the 2016 data, not 2018, of all these folks. Here's what you need to pay attention. This axis runs the large contributions. This is, what percentage of that you're getting. Look at Sanders, essentially no big dough. It's all small cash. Trump is a very interesting case that I've written about before. He has real small contributions, but he has also a ton of big money. It wasn't just his, in particular in the later stages of the campaign, coming from private equity. You've got, and if you notice, Clinton and Schumer and Pelosi, they all look a lot alike like the Republicans. There are essentially two souls in the Democratic Party right now, and it doesn't take a genius to figure out where the antitrust soul is real. I mean, in the nature of the case, it's pretty much like Mr. Lowe's case there. People will talk about making something effective. My advice, and Elizabeth Warren is right when she said, why are these guys taking all the cash and still running for president and talking about that? That point could have been made at any time in the last 30 years. And Warren's own plan for political donation regulation last year was simply ridiculous. I mean, she just didn't want to take PACs. Now I think she seems to have learned her lesson. It helps, no doubt, as you can have one billionaire after another come out and say they really can't abide her. But anyway. Now, finally, I got to get to the papers. Okay, look, first, just basically, it's like Venus de Milo, as far as I'm concerned. What are you going to do, say it doesn't have arms and roll your nose? I don't think so. These are great papers. The Glick and Ruetschlin, the Srinivasan paper, they're terrific. I have, admittedly, the conflict of interest in the spirit of the Texas dean who said, where there's no conflict, there's no interest. That was a true statement. These are folks that I'm happy to say I work with now, along with Pia. And so we'd say they were probably good, maybe if they weren't. But I have some question about a couple things. Much as I like Dina's great paper, I just thought it was a fabulously written, beautifully researched. It's just hard to imagine a better job. I got a few problems with the confidence the competition would fix this stuff. Here's one. I actually, to my knowledge, the only person who actually looked at the Standard Oil papers that wasn't sort of screened off by the companies. Never mind how I did it, I did it. When I got in there, I could see a couple things. One was that the amazing hawk-like sense of, here's a potential threat. It's like if there was somebody opens a refinery in West Virginia and starts shipping oil someplace, they're on it immediately. And the other thing that comes out in the stuff I saw was they were just buying newspapers and writing things like, okay, we need to get an article in an elite press thing right away, and then you could actually go back and track it, and boom, it would push it somehow. One thing you should pay attention to in the U.S. press is that if you notice, people don't stay forever in the modern media. They have a tendency to leave after a while. Almost all these people are looking, what are we going to do next? Many, it's clear to me, I've dealt with too many of them over the years, since like the third Egyptian dynasty or so. I go back a while. They are hoping to get jobs in some of these companies. And that just, the visions of sugar plums dance not only in Zuckerberg's head, but in a lot of newspapers reporters. No one says anything, but that's it. You can see the way some people have gone, even from the New York Times to investment houses. Yeah, okay. So I have some doubts that Zuckerberg wasn't thinking early on about the growth of good information and its ability if you could get a real monopoly. And in that sense, they were pretty obviously never believing their privacy thing. But this question, 2 and 3 here, are really important. One is, how many firms would you actually have to get real competition? Some research, I mean, people have been using the Herfindahl indexes and stuff. Look again. There's some good work now that suggests, well, you probably need 6, 7, or 8, and even that might not be enough. And the big point is that oligopolies are going to behave more or less like monopolists, except they're going to have to share in the trough. Obviously, nobody can get quite so much. But they will figure this out over time. And then this third one is where everybody is blind, where the importance of financial concentration. We don't have to argue about this anymore. Martin Schmaltz and various colleagues, he has a terrific memo for the OECD. It's pretty easy to find. If you type Martin Schmaltz OECD into Google, you will probably find it, which sort of shows you how, in fact, just ownership by mutual funds of a certain branch they actually coordinate apparently decentralized industries. I have been all my life skeptical about strong finance capital hypotheses, but I think Schmaltz really has nailed it with really good empirical research. And some of our work at INET, where Eileen Applebaum and Bill Lazanik and company, private equity is helping to drive up the costs of healthcare. You've got to be an idiot not to see that. And that's when these folks buy into places, their behavior changes. And if you think they're running competitive operations, look again. Finally, I think the Warren episode, that's the one with Zuckerberg. We have got to find a way quickly to find out what's really going on with those algorithms and things when they get close to politics. Back about 25 years ago, some political scientists ran sort of an experiment where they got real but not used CBS News outtakes, gave control groups like this was actually in the election of 1980. Since I got no time left, I'll just put it very simply. They showed you stuff that was heavily slanted against the Russians. Now you could say, hey, isn't that the case for as long as you can remember? Sure, okay, but never mind. And then they had the group that was just watching the real news. They found significant differences after about 6 weeks of exposure. If this stuff happens on the internet and you do it subtly, it's not like you turn night into day, or that it's 1984 where you just suddenly somehow change your whole views. No, it's like you can shade opinion 3%, 4%, and 5%. Facebook has run some experiments on that. There are good records on this. Nobody can tell at the moment, but I doubt very much that anybody can tell in real time how political ads might be subtly slanted. It's a question that Warren raised. It needs a quick answer, because this is a fairly ridiculous situation, though I think actually that the empirical evidence that I've looked a lot at, and I've worked on this myself, says that Facebook's influence on politics is much less than people think. The reason is because people don't control for the other stuff that's provably also driving people's opinions. It is just the case, for example, on sort of raw correlation. More people on Facebook were voting for Hillary Clinton than for Trump. But that's another day, another argument, another set of statistics. My sort of comment is, these are great papers. You should read them all, and for once, believe them.
Thanks. Okay, Tom is always a hard act to follow. But let me also start by thanking Mark and Catherine and the team you'll have here at the University of Utah. This has been an exceptionally interesting conference, and I agree with Tom. I've learned a tremendous amount, and it's just been very enjoyable. And thank you. I'm going to focus today on the papers by Dina and Mark and Catherine. And once again, I think they were both excellent papers, and I agree with everything that you guys have here, and I'm very pleased that INET is supporting this work. So Yesterday, the sessions began by laying out the division between those who believed that the issue of increased concentration is a problem with under-enforcement of current antitrust laws versus those who see a more structural underlying problem. And what I think is interesting about this morning's papers is that I think we're seeing both these issues explored in a fair amount of depth, and seeing that the issue really is in both sides of this equation. But the dominance of the Chicago school in the US is, and the focus on the consumer welfare standard seems extreme, to the point of being out of step with most of the world, where there seems to be a much greater acceptance of the role of competition to achieve a broad range of goals, including income distribution and employment, national security, and even cultural diversity. And over here, there's always this struggle about, well, should we be bringing in different tools to deal with this? I think it's really unique to the US that we tend to be so focused on this issue of consumer welfare and the focus on efficiency. But in this case, Mark and Catherine are focusing specifically on the damage wrought by the Chicago school interpretation. And Dina is showing that despite the fact that we have these regulations in place, they're being undermined. Even the existing laws are being undermined simply through deception in the case of Facebook. So I have a couple of brief comments on the papers, and then I'd like to point out a broader set of political concerns, which Tom alluded to in his last slide a little bit, and specifically in the case of Facebook, which at least two of these papers concentrate on. So first, with respect to Catherine and Mark's paper, I believe that you make a very convincing argument that the shifting of the goalpost from the structural approach to the vaguer effects-based approach is highly destructive. This is likely to be especially true in the case of big tech, because tech is developing so rapidly that it's harder to assess the future. And it seems imperative that we should be erring on the side of caution. And you also point to a case where it's possible to see the trade-offs with respect to efficiency. So one of the issues that was brought up yesterday as a critique of the neo-Brandeisian approach is that we need to be thinking about the trade-offs. And you point very clearly to the fact that Instagram would very likely not have reached the level of engagement and revenue generation without being a part of Facebook. But it's also clear in retrospect, almost everyone looking back at that merger is very clear that this is the one place that we need to be thinking retrospectively about going back and possibly breaking these up, because it's one of the most egregious examples of the failure of the antitrust system to rein in concentration. So that concentration should serve as a structural rebuttal presumption when a dominant firm purchases a potential entrant seems entirely apparent, highlighted by the fact that it was made clear to everyone before the acquisition, especially in the case of Instagram, that it was being done to prevent competition. I don't think anyone had any doubt about the fact that Facebook was looking at Instagram and saying this is a potential competitor and that's why we need to control it. And the idea that we do not have laws on the books that allow us to actually step in a case that's this obvious even before the fact, right? And to be able to say something like Instagram is not monetizing its user base through advertising yet, when we all know that that's exactly what the model is, that you build up through your network effects and then you monetize through advertising after you've built it up. But the fact that they haven't gotten there yet means that we can't actually prevent this from happening, is a clear indication that there's a problem with the way our regulations are structured. But in some ways, the issues that Dina presents in her paper are even more concerning, because here we see that the laws exist and we see a pattern of deception from Facebook. And we know that this is the basis of the collapse of trust that was in full view for all of us during the hearings last week. Dina's focus on revealed preference and the issue of privacy is very interesting, and I think especially with reference to what you just showed us today with Luther's Mechanical Turk experiment. Because economists have been playing a lot with this idea of how do we actually put a price on privacy. And what we've discovered through behavioral economics is that we have these huge differences between consumers' willingness to accept compensation for privacy loss versus the willingness to pay for privacy. So a recent study by Winiger and Sunstein found that consumers would be willing to pay $5 a month to delete all their personal data from companies that have collected it. And keep in mind that Facebook makes about $30 a year on each user. But when you ask consumers how much they would need to be compensated to hand over personal data, it averages about $80 a month, or almost $1,000 a year. So as economists, we're so torn between this compensation, with the willingness to accept and willingness to pay standards, that we don't really even know how to answer these questions. So I think your example this morning was a very good one when you just look at the revealed preference. And in the case of competition, we see that users really are showing us a revealed preference when given a choice, hence the ability of Facebook to snatch market dominance away from MySpace, and the user loyalty to WhatsApp, where Facebook committed again very strongly that they were not going to change WhatsApp's promises about privacy, and we're seeing that eroded as well. So while increased market concentration is a concern across the economy, not just in technology, I believe it's particularly dangerous here because technology has the potential to reshape political and social institutions. Work done by Tristan Harris at the Center for Humane Technology shows how effectively Facebook and other technology companies have figured out how to hack our brains. They are consciously shaping the thoughts, feelings, and actions of human beings, essentially programming people. And we know this from people on the inside who have worked within Facebook. We understand that they're using psychological models to hack us at a level that is far more sophisticated than even advertising companies used to do. Madison Avenue has nothing on these guys. So when we have monopoly power like this in tech companies, it means that the ability to restructure our institutions is falling into a few hands. And increasingly, the incentive structures are pointing them to using this power to further consolidate it. The fear is that there will be a tipping point where the ability to control our information, guided by an extensive knowledge of our individual psychologies, is used to ensure that democratic structures are controlled to limit any interference in the future consolidation of power. I think in particular I'm referring to the Warren Zuckerberg spat that Tom referenced earlier. Once, if and when Facebook decides to get involved, and it's very hard to imagine that there will not be a finger on the scale, given that these algorithms are completely opaque to us, in the direction of someone who is less likely to enforce any kind of control over them going forward. And so when you have this cycle of them encouraging people who are looser with regulation, and the looseness with regulation giving them more and more ability to build up their monopoly power, I think you're going to reach a tipping point. And of course, it's particularly scary when we consider the idea of Facebook entering financial markets. And think about the monopoly power that can accrue there. So, the US currency is fairly stable, but when you're talking about currencies like Venezuela or various other countries, which Facebook is specifically pointing to, saying, wouldn't it be nice for them to have a stable currency? You can imagine how quickly it's possible for something like this to take over these currencies. And we can only imagine what happens when you have the potential of a Facebook that's too big to fail. Last week's hearings highlighted the dangers of monopoly concentration in the hands of tech companies, and it has very clearly shown us the limits of corporate responsibility in the absence of regulatory structures to rein it in. Representative Sherman's comments about Zuckerberg's lawyers finding a loophole in a 1940s Investment Company Act to gain regulatory approval is exactly the kind of issue that we're dealing with here. As Catherine and Mark show, that we need to rethink not only our current regulations, but also the ways in which they will need to be enforced, as Dina shows us with her paper. Thanks.
Thank you. I thought it might be helpful for you to start with the experts and the scholars who write in this area really have two audiences. One audience is each other, and you write in a highly technical language and use formulas that make no sense to me at all. The other audience is people like me, and in many real sense, I'm a gatekeeper. You don't get to a result unless you get by me. And that happens at two levels. First of all, I'm going to look at the experts and say, is this an expert? Is he qualified? Is his opinion admissible? Am I going to allow the jury to hear this? The second is, you're going to have to get by a motion for summary judgment. If I don't think you satisfy the requirements in a case for summary judgment, so when I read the paper about Facebook and whether there's an antitrust claim against Facebook, I say, does this survive summary judgment? Does this ever get beyond the academics to a real jury? So let me back up and give you just a little perspective of the kind of audience that you're probably talking to. I'll use myself as an example. There will be other examples, but you can count on the fact that almost no district judge that's going to be sitting as the gatekeeper will have the kind of expertise or spend the time studying that you as scholars have done. So my background is I wanted to get into law school, so I did not take any economics as an undergraduate. I majored in English. And so for the next 10 years after I graduated from law school, what did I do? I spent 10 years studying economics. I worked on a number of antitrust cases while I was in California and some after I came back to Utah. And was assigned to work on the economic development part of the case. How important are the economic experts? I'll just tell you a story. One of the cases I worked on was the fight between Al Davis and the National Football League in terms of whether they could move from Oakland to Los Angeles. We tried that case twice, 3 months each. And I was in the middle of presenting the expert witness on the economic issue that was actually at the heart of the case. And the trial judge, Judge Ferguson, called me. He said, "Mr. Waddoups, come up to the bench." He says, he said quietly, he says, I know you think this is really important, but the jury doesn't get a damn. Get him off the stand. And so the economic basis for the defense of the National Football League was presented by deposition. So what is the role? I'll tell you another story. This was a case in which Professor Curl was also involved. It was a very complicated case involving significant economic issues, a fight between Visa card and the Discover card. All kinds of interesting issues of what it took to create a market and who was the market and what kind of powers were at play. After the case was over, in which I represented, the team I was on represented Visa, we interviewed the jury and said, well, why were you so impressed by Discover Card's presentation? And the juror said, well, they described a credit card that I thought I'd really like to have that credit card. And so we voted for Discover Card. So how important is the economic analysis when you get down to the final? You'll have to be the judge of that. Let me give you a couple other things. In my early years when I was at Old Melviny defending IBM and defending the National Football League and when we were defending Visa, a lot of the arguments we made were based on the Chicago School of Economics. And I think that those cases and many others, not just those cases, but many others, drove the law to the point of saying, well, we just look at consumer welfare. If this is good for the consumer, then we're very reluctant to change it. After 45 years and having watched what's happened, I've become very skeptical as to whether that's the right measure. Because it seems to me the underlying premise of the antitrust laws is that competition is what produces good results for the consumer. And it turns the analysis on its head if you start by saying, well, is this good for consumers? Well, it might be good for consumers for the next year. It might be good for consumers for the next 5 years. But if you look down the road, competition is what's going to protect consumers. So I've had a complete kind of shift in terms of my own thinking about the role of antitrust law. Now, come back to the specific cases that we're talking about here. Does the motion for, does the case against Facebook survive summary judgment? First of all, I don't know whether the experts are going to get to testify or not, because you don't have a well-established basis in which you can say, look, all of the industry experts can agree that this is how you define the market. This is, the industry experts will all say, well, this is an appropriate analysis. You're facing a case in which there is no precedent. You have no pricing. You have no, you can't look at the normal factors that you would normally look at in a normal case and say, yeah, this is relevant expert testimony. Now, based on the presentation on one side, I would probably say, yeah, these experts should be allowed to testify, and the jury should be entitled to hear their case. But there's going to be another whole other side and say this is just off the wall, because there isn't any precedent, there isn't any strong recognized economic theory that would support this. The second thing in the Facebook analysis is, assuming that you find that there is market power, which would be a difficult analysis in the Facebook case, I think based on the presentation, the paper, and I thought the paper was really interesting, by the way. I should tell you a story about privacy. When I first went on the bench, one of the things that the United States Marshals, who are responsible for security, said, don't go on Facebook, don't go on any kind of social media, because you can't protect your privacy. And I was at a seminar in which one of the high officials in the security department gave a demonstration. And he had it on the screen, pulled up all his stuff and said, give me your name and your birthday. He took the name and the birthday of the person, and within 5 minutes was able to tell what kind of car they drive, where they lived, how many children they had, all of their personal information. He was able to do it from just 2 factors. So privacy just doesn't exist in the Facebook world. And I took some comfort for quite a while, the fact that I didn't become a member of Facebook, don't have a Facebook account. Now I'd learned from reading your paper that if I go on Google, Facebook gets all my information. So that's a critical issue. But now to put that into an antitrust analysis, assuming we get by the hurdle, I'd say there's enough information for a jury to decide whether there's market power here, which it would appear to me based on these papers that there probably would be. Then I get to the next step. Traditional analysis is, do I have predatory acts? What are the predatory acts? You've got to be really creative to go beyond the prior precedents to find that Facebook is engaging in the traditional kind of predatory acts that the courts have found to be violative. I mean, we're in a situation where they've got to either achieve or maintain monopoly power by some kind of predatory or anti-competitive act. What is the specific anti-competitive act or the predatory act that you would point to in the case of Facebook and say, this is what crossed the line? What do I tell the jury? If Facebook did this, then you've got to find that they violated the antitrust laws and are liable. So in terms of looking at this from the perspective of a gatekeeper, I think this is a great piece of work, and I think it's a significant problem. But I think that looking to the courts to solve this is going to present some significant hurdles to get across. There are some further practical matters. Mark suggested that I might give you just a little bit of background on the Entrada case that was just settled. That case involved some rather complicated and important antitrust issues. I concluded that the experts should be allowed to testify in some respects. In some respects, they shouldn't be allowed to testify. Frankly, Professor Curl, I was really looking forward to your cross-examination. And you should understand, I know Professor Curl pretty well. He was involved on the opposite side in the Visa case. He's also been an expert for me when I was in practice, and I have great respect for him, both as an expert witness and as a professor. But there were some interesting, difficult issues in that case because of the kind of data that was presented. It also involved some complicated issues as what do we do with a company that has pretty clear evidence of market power in one market, but then has a second market in which It doesn't have market power, but it's using its market power in one market to control the ability to compete effectively in the second market. How do you bring those two together, and how do you marry them in such a way under traditional antitrust law analysis to make sense of them? And one of the problems that we face, we've gone so far down the road, and I guess it depends on where you come out on your views of this, but we've gone so far down the road in the courts in terms of the Chicago School analysis that you go read the cases, and the cases are going to be very, very strong. For example, in the Entrada case, we had an issue as to whether there was a presumption that should apply that would say if I'm operating within the realm of my copyright, then I have a complete monopoly. And the only way that you can look for conduct outside of that is whether or not you can show fraud or some illegal acquisition of the copyright. So we have a case in the 10th Circuit written by my former partner, a woman whom I have great respect for, named Solid FX, in which the analysis was, well, there's a copyrighted issue, and the only way you can rebut the presumption of the copyright, relying on some Federal Circuit cases and other circuits outside the 10th Circuit, saying the only way you can rebut this is by these two ways, fraud or illegal acquisition of the copyright. And then she writes, but there was no rebuttal put on in this case. And so we have a statement saying this is the only way you can rebut the case, but it's clear dicta. If you apply the facts of the case, there was no need for her to have reached that decision. So I refused in the Entrada case to apply that presumption, saying, well, I got to hear the evidence. Which brings me to the second part of the problem. There is a trend that I see developing in the law. For a long time, initially, we fought over the issue of per se illegal conduct, price fixing and various things. And the court said, if we identify that it's per se illegal, then we don't have to go into the economic analysis as to whether there's pro-justification or not. As the courts began to have more experience, they said, well, wait a minute. Maybe we've been a little too quick to come to the conclusion that this pro se conduct is always bad. So around the edges, it got shuffled up a little bit. Now we see a trend going the other way, saying they're not calling it pro se legal, but it's exactly the other side of the analysis in which the courts are saying we have a presumption that this is legal, and you can't get beyond that presumption unless you show a couple of things. But we don't have the factual basis. We don't have the legal analysis in terms of trials with court cases and juries and the courts writing decisions saying, does this really meet the standard? Are we so clear that this is so good for consumers that we should find that it is presumptively legal? And I think we have, for lots of reasons I suspect, but we have courts writing decisions without having a factual sound economic basis to pronounce the assertions that they're making in terms of whether something is legal or not legal. Which brings me to my last point, the practicalities of it. The Entrada case was a case in which both parties were very well represented. There were times on hearings when we had 10 lawyers in the courtroom on both sides, and they weren't cheap lawyers, I can assure you. Just to give you a little bit of understanding of that, there was a discovery problem that I found was a bad faith, and that it caused one side to incur significant increased expenses and precluded a bunch of evidence from coming in as a result of the discovery abuses. The attorney's fees that I awarded in that case for the discovery abuses was $1.9 million. And sometimes people criticize, say, you judges don't enforce your rules. Well, I tried to in that particular case. Which brings me to my point. If the case were to be brought against Facebook, who would bring that case? Who is it in our existing political structure and in our existing economy that would be willing to come forward with the amount of money necessary to challenge Facebook. That would be an extremely expensive fight. It would go on for a significant period of time, involve significant discovery, experts, and delving into a very technical and difficult area. Who's going to do that? Is the Attorney General's office going to bring that dispute? Maybe. But I'll share my skepticism with you. My experience is that if you're an enforcer and you're an attorney representing the enforcer, you want cases you can win. You want a clear laydown. You don't want a case that's going to spend millions of dollars on, and then the jury comes back and says, well, I really like my Facebook account. So I think that's a practical problem in terms of bringing these challenges. On the political side, are you going to put your career on the line and say, I can win this case? Which is what the lawyers would have to do from the Attorney General's office if they were going to bring this dispute. So while I think these are very real problems, moving beyond the academic level to the practical level as to how we change them in our economic structure is, I think, a formidable problem.
Anyone want to respond? Dina, how are you going to bring the case?
Well, I'll point out a few other buckets of conduct. Here. I'll just say on the conduct side, from a predatory or exclusionary perspective, I think it would be very sad if we could not bring a case on the pattern and practice of 10 years of deceptive conduct in Facebook's case. And I would say, and Carl Shapiro talked about this a little bit, especially so in markets where there are very strong network effects and that are going to tip to one player. When you're operating in that kind of a market, deception can really increase how fast those network effects work and can tip the market even faster. And so it's a very effective tool to basically lock in the market to achieve a monopoly. Deception, that is. And on the deception front, it wasn't just that Facebook entered the market promising privacy and then changed it 10 years later, the same month that Google exited the market. It really was a pattern and practice. It tried to change the privacy term on users in 2007 honestly, and consumers flipped out and left, and Facebook had to retreat. In 2010, it introduced an unrelated product, and consumers were like, well, gosh, this looks very similar to what you tried to do 3 years ago. Are you sure you're not going to use this to track us? And several Facebook executives over the next 4 years continued to represent that it was not going to be used for tracking. In 2010, Facebook quietly filed a patent in order to use the technology to do precisely that. So if you take it all together, it really does look like a pattern and practice case, and you do have the FTC case against Intel, although it's not under Section 2 of the Sherman Act, which also goes after this pattern and practice of deception. I'd say that aside from the conduct on the privacy side, which looks deceptive, you have a bunch of other buckets of conduct that I think may be actionable under Section 2 of our antitrust laws of the Sherman Act. You've got a bunch of conduct where it looks like Facebook is trying to create network effects. So, Catherine, you mentioned when Facebook acquired Instagram, but when Facebook acquired Instagram, you could actually use a different social network, post a message, and have that message distributed across Facebook. So it was kind of like the way phones work today. If you use Sprint, you can use Sprint and send a communication or call, text or call somebody that's using AT&T. It used to work similarly on Facebook, and they revoked basically competitors' ability to be able to send communications across networks. You had that, so the very real example is you used to be able to compose a message on Twitter and have it actually post to Facebook users. You had a similar thing with Facebook messaging. You used to be able to compose a message on Facebook Messenger, and it used to cross-post to other messaging products like AOL's ICQ. You used to be able to export your list of contacts to competing social networks. And you had more recently, I think after 2014, conduct where Facebook shut out competitors from using these interoperability tools. And you have at least some evidence where that conduct is coupled with language that looks like the purpose was to discriminate against rivals and to keep them out of the market. So I hope you're wrong on somebody bringing the case, but I think the other points about how hard the case is, who's going to bring it. I will say that the reason why I wrote the case as a class action on behalf of consumers was precisely because I thought that nobody in government might bring the case or would sort of bring the case. But if somebody was brave enough to do it, it would be great if it went right to the judiciary, because I think this question of privacy might rub that branch of government a little bit more strongly.
I should say in response, I was convinced by your paper that the case should be heard.
Oh, okay. Oh, that's great.
I just think it's a difficult challenge.
Yeah. No, I agree. Definitely. We also have the statute of limitations problem.
Yeah.
Please. Yep.
We only have time for anyone else on the panel have a quick word. Otherwise, we're about out of time.
Mark, why don't we see if we can just take a bundle of maybe 3 questions to provide to the panel before we wrap it up. Is that okay?
Sure.
Let's take all 3.
Right.
I think that the panel's sophisticated enough they can digest it.
Hi, so it was a great panel. It was my favorite panel of all the panels. And I have a comment for Dina and Luther, especially the last slide you showed about Facebook and how you showed that people are not willing to click, to share their data with Facebook. So I would say that's a weak evidence against Facebook. A stronger evidence would be an opt-out strategy where you have boxes which say, I do not want to share my information with Facebook. And if you find consistent results, then I think that's a much stronger evidence. And the second point was, you can also find willingness to share your information with Facebook in return for money and find out how much you're willing to accept from Facebook to sell that. So that'll maybe make your case stronger.
Thanks, that was a really interesting panel. I just want to bring back something I raised briefly yesterday, and I want you all to tell me why this is stupid. A lot of complaints against Facebook, and clearly, I'm convinced there's a very good case that, they're engaging in anti-competitive practices. I'm not a judge, so I'm not a gatekeeper here. But some of these things seem to me that they are not necessarily linked to whether or not Facebook's a monopoly. So just to take the obvious case that's been there, Mark Zuckerberg says, I can take out political ads and lie. Okay, I can't do that in the New York Times. Okay, the New York Times would be subject to libel law. Many of these privacy issues. Suppose there were 10 Facebooks and half of them, or 10 different companies, social media companies, and half of them violated your privacy. Would that be okay? I still think that'd be a serious problem. So in other words, my point is that these are regulations that are not necessarily directly related to anti-competitive practices, which again, I take the anti-competitive practices seriously. I think the idea of breaking up Facebook is really good, but these problems would exist whether or not Facebook were a monopoly.
One more, Norm? One more? Only one more.
Yep.
This question is first for the judge, but if anybody else on the panel wants to take it, it's fine. Dina's paper focused on the harms on the consumer side, which, as you noted, is the zero price side, which presents problems for a plaintiff. But what if a case instead were to focus on the advertising side, where you have prices and you actually have contracts with Facebook, with various third parties, OEMs, app providers, advertisers, publishers, that contain exclusionary agreements or provisions that might be associated with higher ad prices. Would that be a case that you think would have a better shot in a court?
You want to take that one first, Judge?
I think that there's a good argument there that would be sufficient. The thing that this case would have going for it is the adverse reaction almost everybody has is the misuse of their privacy. Just talking to people that I know and to my staff about this, I don't want to use Google anymore now because I find that Facebook gets my information if I use Google. And people are, I think, generally reluctant to have the misuse of their private information. The difficulty is it doesn't fit any clear case law in terms of where you would come down and say, if I'm a judge and I'm going to allow this to go to a jury, I can hang my hat on this. You got to have a judge that's willing to be somewhat creative and look at the real substance of what's going on and say, notwithstanding what every other case has ever decided, I'm going to let this go to a jury.
Okay, anyone want to take Dean Baker's question about we need libel law anyway?
Yeah, I do. I also was thinking about the same question because Tom asked during his presentation, would competition fix these problems? And if so, how much competition do you need? And I think it's pretty closely the same question. And it just made me think of actually what Dean and his co-panelists brought up yesterday, which is that government creates and facilitates these markets. So there's a lot of room for government to define the structures in these markets. Antitrust is one of those ways. But there are a lot of markets where the market-driven outcome is one that we as a society have decided that we don't want to live with. And we've intervened through minimum wage laws or things like that, democratically as a choice to instill values beyond just the privileging of the market system. In the case of big tech, and specifically the tech platform companies I was talking about, they're prone to tipping. The market-driven effects will lead to a single dominant provider. If we decide that we want the market to allocate those goods and we're willing to live with that outcome, one of the things that should be part of that decision is that, well, we should have as much of the market-driven enforcement and impact as we can as in that decision. Potential competition being the main source of competition in markets that tip would be especially important in that case. It doesn't negate the need for us to establish as a society that we value other things outside of simple market allocations, but it's still a critical part of the regulation that would go into creating and facilitating those markets.
Thank you. Luther, do you want to take Pavitra's suggestions?
Sure.
Yeah, so admittedly, that example was sort of a silly one. The context was that I'd just met Dina, and I loved this tweet that she'd put out showing, as a hypothetical example, imagine that the Facebook login looked like this. And I think I was just trying to show that in 5 minutes we could throw that into the magic machine and get some interesting data. And in that case, it told us this isn't a good experimental design. But I think the takeaway is that we need more behavioral economists like yourself involved in these questions to assist on the behavioral design. I've thought a lot about the Google issues and how to do usability studies, but I think you could apply these tools to virtually any consumer-facing internet platform or app, and there seems to be, and whereas the 3 iterations of the Google settlement took 2 years from Europe, there's no reason that enforcers shouldn't be looking at hundreds of iterations a week if an actual remedy negotiation is going on. And so please tell all your behavioral economist friends to get more active in antitrust.
Well, folks, that concludes our conference. I hope you enjoyed it. I do want to thank the economics department staff and the Charles River staff for their huge effort. You don't see it, but the logistics of all of this were tremendous and took a lot of work. A couple of announcements for participants. There's some boxed lunches in the back room. And please remember, if you've stored your luggage because you're on your way to the airport, don't forget that that's locked in the back as well. Otherwise, I want to thank everyone for attending and all the participants. It's really been great, and at least I had a great time. Thank you very much.